which will be led by Matt Jacobs, our General Counsel. He'll be joined by Ashley Dunning, our Fiduciary Counsel. Hello, Ashley. How are you? And Mr. Jacobs, you want to get us started?
I would. Thank you. Good afternoon, everybody, and welcome to our annual fiduciary training. This, as you know, is the annual training that's actually required by the board's governance policy. Now, I'm listed on the agenda as a moderator, but I'm probably more accurately described as the introducer. But with that said, I would welcome any questions that are directed to me, and I may interject from time to time to supplement Ashley's comments if I see an opportunity to say something. So with that, let me just introduce Ashley, who I think everybody knows pretty well, but we have some new board members who may not have heard from her, or may have heard from her only once or twice. Ashley has been CalPERS' fiduciary counsel for the last several years. She is a nationally recognized fiduciary advisor to public pension boards throughout the United States. In addition to CalPERS, Ashley serves as fiduciary counsel to 16 of the 20 California county retirement systems and the city retirement systems in San Francisco, San Diego, and Los Angeles. She has also provided fiduciary training to boards and industry groups throughout the country. She is currently the president of the National Association of Public Pension Attorneys, and has been on the executive board there for several years. So with that, I'm going to turn it over to Ashley to get us going.
Great. Thank you, Matt. And I think I'll stand up here, as I tend to do. Good afternoon, everyone. As the president noted, this is your required training, and some of this will look quite familiar to those of you who've been on the board for many years, for whom I've given fiduciary orientation training as well. But I do try to add things every year to reflect recent articulations of fiduciary duty in the law, recent cases that I think may be of interest to you, and certainly welcome any questions that you may have as we go through this. It's intended to be interactive. We start out with sort of the very high level of what is a fiduciary. Why is this so important that we talk about it? The essence of a fiduciary relationship is that it's one of trust between you as the fiduciary and the one that you serve, or the ones, in this case, whom you serve, the members and beneficiaries of CalPERS. We fiduciary lawyers often cite to Justice Cardozo's very famous statement about the fiduciary relationship when trying to impress upon fiduciaries the importance of this, to note that it's something stricter than the morals of the marketplace. It's not honesty alone, but the punctilio of an honor, the most sensitive, that is the standard for this behavior. Who are fiduciaries? Many of us are fiduciaries in the various different roles that we play. I, as counsel to CalPERS, am a fiduciary to CalPERS. You, as fiduciaries and trustees on this board, are fiduciaries to the members and beneficiaries of the plan. I've given other examples of fiduciary relationships, shareholders, directors to shareholders of a corporation, for example. And I've already noted this, but why does it matter whether you're a fiduciary or not? Well, it matters because the law holds you to a higher standard of behavior as a result of this role that you have. And you are considered in this relationship to be the dominant party, the trusted party. I've said it once and I'll say it again. Under the Ninth Circuit law, they talk about these duties as the highest known to the law. When we delve into fiduciary duties, we need to talk about it in terms of its two different prongs. We have the fiduciary duty of care and the fiduciary duty of loyalty. And I'll talk about the fiduciary duty of care in the first part of this presentation and then move to the duty of loyalty. The fiduciary duty of care is encapsulated, as is the fiduciary duty of loyalty, in the California Constitution, actually. As many of you know, when Prop 162 was passed, it even reinforced and made stronger. So, fiduciary duty of care is one aspect of the prudent expert rule is part of the fiduciary duty of care. Sometimes people will say, well, I'm not really an expert. I'm just a regular layperson, and can't I just be a careful layperson? And the answer is no. You are actually deemed to be subject to a prudent expert standard. And I've quoted the language from the California Constitution, which tracks the ERISA standard as well, which is the standard that applies to trustees of private plans, not governmental plans. And it's from this language that we get the statement that you are subject to the prudent expert rule. So you're supposed to know what you're doing, as a prudent person would, who knows what they're doing in a particular arena, whether you're talking about actuarial matters that you're handling, investments, disability, retirement, governance, whatever it might be. There's quite a recent case that I spoke in my last presentation to your board about, which is a California Court of Appeal case called O'Neill versus Stanislaus County Employees Retirement Association, and it reaffirmed the fact that courts will look to the restatements of trusts and general trust law principles when assessing whether boards of retirement or boards of administration, a board of administration in this case, have complied with their fiduciary obligations. There are a couple of important parts of this quote, and the quote is, as an initial guideline, a trustee has a duty to administer the trust diligently and in good faith in accordance with the terms of the trust and applicable law. Why is that so important? It's important because the terms of the trust are your plan document. That is the law that's incorporated or included in the Public Employees Retirement Law, other aspects of the government code that apply to you. And in order to be a prudent fiduciary, you need to follow those terms, as well as other applicable law that governs you. Delving further into the prudent expert standard as it applies to you as an institutional investor, the prudent investor rule also reflects this obligation that you possess. That you comply with the standard, and also notes that to those of you who have special facilities or knowledge in a particular area, perhaps your day job is related to investments, you actually are required to use those special skills, share them with your co-fiduciaries on the board, not to become the investment advisors for the board, but rather to inform the collective of your thoughts in those areas where you have special expertise. The standard to judge whether you're complying with your fiduciary duty of care is one that is objective. Would a reasonable person conclude that you are complying with this standard? Not subjective. Do I think that I'm complying with this standard? And the famous quote on this one is from a case called Donovan versus Cunningham, which says that prudence in that context in investments, but generally as well, is not met by having a pure heart and an empty head. So a very astute visual of what we're talking about. Similarly, as this comes up from time to time, is the fact that you're a layperson good enough? And the answer is no. The prudent standard is not that of a layperson, but rather of a prudent fiduciary with experience dealing with a similar enterprise. So again, the prudent expert standard. And there have been cases, and I'll talk a little bit more about this case in the following slides, where courts have actually probed the thoroughness of fiduciaries' analyses to assess whether it was prudent or not, rather than simply deferring to what the fiduciary decided in their best judgment was acceptable. Howard is an interesting case. It's an ERISA case, so it's under law applicable to trustees of private funds, not public governmental funds. And there are some laws applicable to governmental funds and some of the rules that protect all of you in that context that are different. That said, I think it is very important to think about this case for what it demanded of the trustees. And that was in the context of consideration of whether an ESOP was handled prudently, whether the valuations that were provided were sufficient. The fact that the trustees had gotten a valuation from a Big 8 accounting firm was deemed to be insufficient when the judge sort of substituted the judge's views for that of the fiduciaries and said, if you looked behind those numbers at all, you would have seen that they were not reasonable. Why did the judge do that here? Probably because it was a self-interested transaction. Because the lower the value of the stock, the more beneficial it was to the directors. That may come up from time to time in a pension plan context. You do not have conflicts of interest from a Political Reform Act or governmental, 1090 perspective, because the Supreme Court in California has made clear that when you're acting in a manner that is that impacts you, such as by the setting of your various terms, setting your actuarial assumed rate of return, active employees of the system are going to pay more or less depending upon what that is. That impacts some of you financially. That's not a prohibited conflict of interest. Those are the types of decisions, though, that a court, if you were challenged, might look at a little bit more carefully. Something that is specific to trustees of a public retirement system that is also included in the Constitution in connection with fiduciary duty of care is your duty to assure the competency of the assets of the retirement system to pay the promised benefits. How do you do that? You do that by retaining your control over actuarial services provided to the retirement system, which is why you have your independent in-house actuary, as well as advisors who tell you what the necessary contributions are to receive from your employers in order to pay for the promises that they have made to their employees. The case I mentioned earlier, O'Neill, is an important one on this because it dealt with actuarial determinations that the board had made. And the challenge to the Board of Retirement in that case was challenging the actuarial methodologies that they had adopted in the wake of the Great Recession. Which included transferring some money out of non-valuation assets into valuation assets, expanding amortization schedules, and the like to deal with the great volatility that had arisen in around 2008, 2009. The court in this case did a really deep dive into Prop 162 and general trust principles to assess whether there was a breach of the duty of care or potentially the duty of loyalty, and talked about the importance of Prop 162, which I mentioned earlier, which was, as the court said, quote, an apparent response to fears that the legislature was raiding pension funds to balance the budget. Well, which pension funds were those? Those were the ones administered by CalPERS. And so it was in reaction to that you have now this sole and exclusive plenary authority subject to your fiduciary obligations to manage actuarial services. And it was moving the control from the employer, who obviously has a self-interest in having rates go a particular direction, to you as the trustee who have the much larger obligation to look at the big picture and assess whether you are collecting the contributions that you need to now and as projected over time in order to pay the benefits when they're due. So in this case, the court concluded at the first, so this case has been up to on appeal, it's on its third round now. On the second round, the court concluded that the board had not violated its duty of care when it made those various actuarial decisions that I mentioned earlier, as they expanded the amortization schedule, which permitted negative amortization, which I'm sure you've heard about when your amortization schedule is about over whatever, so I'm not an actuary, but 17 years or something like that. There was a challenge to that. The court said no. That was permitted both under the plan document, which in that case is the county employees retirement law, as opposed to the public employees retirement law. But importantly, for purposes of just a cautionary note, the court did defer a decision on whether there was a breach of the duty of loyalty, because the court was not able to determine, based on the motion for summary judgment papers that had been filed, that there had not been a breach of the duty of loyalty. Another case that's come down since I spoke with you last about fiduciary duties, another case involving actuarial matters, is Mijares versus Orange County Employees Retirement System. That just came down last year. And in that case, the retirement system had realized that that one of its employers, because they had no more active employees, was no longer paying into the retirement system, even though they had retirees who were receiving benefits, and there was an unfunded liability that their actuary said reasonably should attach to the benefits due to them. Because they were using a level percentage of payroll methodology for determining normal cost and UAL, they were not collecting anything from this Department of Education in Orange County. And so they developed a new policy that dealt with employers who have no payroll or a declining payroll, so that the UAL, the unfunded actuarial accrued liability, was calculated in a different manner, percentage of liability as opposed to percentage of payroll. And the court in this case upheld that and said, even though there is there was a long history of using percentage of payroll, and the applicable law specifically references percentage of payroll, that doesn't mean that the board was required to use that in this instance under these circumstances. The court noted that the UAL is not a payable debt currently that imposed obligations on employers retroactively. This is in fact an ongoing obligation that you have till the death of your retired members and their beneficiaries. And as I noted already, the applicable law was not a limitation on the board's plenary authority to adopt, in consultation with its actuary, a different methodology. The court made a really important observation that the Constitution, the California Constitution, gives retirement boards broad authority to take the needed measures that assure the competency of the assets of the system to pay retirement benefits. Another aspect of duty of care is the duty to monitor. So the duty to monitor means that just because you made a good decision one day doesn't mean 5 years or 10 years later it's still a good decision to stay with that course of action. That if circumstances change or new information is developed and understood, that it may warrant taking corrective action. In my last presentation to you, I talked about this Tibble case. It's still an important case for us to note. It's a U.S. Supreme Court case, one of the very few involving fiduciary duties of pension fund trustees, although again, this is an ERISA case rather than a governmental fund case. In that situation, the petitioners were contending that the defined contribution plan fiduciaries were acting imprudently, so violating their duty of care, and offering higher priced retail class mutual funds rather than switching into funds that were priced for institutional investors. And the employer and the trustees asserted a variety of different defenses that they thought might prevent the court from going back that as far as they did to assess whether it was reasonable for them to have held on to or to continue with these higher priced retail class mutual funds. And the court said, no, we're gonna look at where you are now as a fund and whether currently you are monitoring and taking corrective action as to what is held in your portfolio. We're not going to simply be stopped from doing that because you made this decision a long time ago. So in that case, the imprudent retention of an investment could provide the basis for a breach of fiduciary duty claim. Did I see a hand? No. Okay. So that case, the Supreme Court did not make the final decision on whether there was a breach of fiduciary duty. They remanded it to the Ninth Circuit. The Ninth Circuit issued a published decision in response to that, which has a lot of really interesting language for fiduciary lawyers and hopefully for you as well as fiduciaries. It too did not make a final decision, but it vacated the prior decision it had rendered and made a couple of important observations in doing so. One is this notion of reevaluating your investments or other decisions that you make on a periodic basis. I've quoted that here on slide 23. In this case, the issue is cost and containing cost management. And so the court talked about that as an important aspect of a fiduciary's obligation in the administration of a plan. Although you're not the ones who actually spend the money as the policymakers, and it's the one who provide the guiding direction to your organization. It is important for you to pay attention to that and ask questions and to direct that changes be made if warranted. Okay, so then it went down from the Ninth Circuit to the trial court to assess the merits of the claim, and the plaintiffs in that case won. So the district court concluded that there had been a breach of the fiduciary duties by the board in that case, both duties of care and loyalty, beginning 6 years before, which was the applicable statute of limitations, and so then the question was damages. I'm not going to read to you this quote. It's very long. The only reason I included it is because some people may take away from a sort of high-level reading of this case that that you had to immediately you have to immediately make changes when there's a change of circumstances, and the answer is that that's not what this case said. They said the facts of this particular case present an extreme situation. The defendants have never disputed that a reasonable fiduciary who was knowledgeable of the existence of this other class of mutual funds would have gotten into it. So that's important. And there were awards of damages and fees. So what do we do in response to Tibble? Make sure that there are processes that are adopted to ensure that there's reasonable oversight on a periodic basis of your investments that are made on behalf of the trust beyond the diligence that's initially done. And we know that you do that through your periodic, the investment office's periodic reports, regular reports to the investment committee. And that monitoring should involve assessing whether your investments as they've changed over time or your other activities as they may have changed over time comply with policies that you've adopted yourself, leverage limits, diversification requirements, et cetera, and have processes in place to trigger more focused reviews if necessary. This is not necessarily a problem that we've noted for CalPERS, but for small systems, there's just this notion that just relying on your managers to report on themselves is probably insufficient. So, you need to have oversight. New topic under duty of care, diversifying your investments. The California Constitution speaks explicitly to your obligation to diversify. You may not put all of the pension fund into one class of assets. Simply putting them in bonds probably would be very much of a violation of your fiduciary duties under the California Constitution. It's a shall diversify the assets of the system, but not in a vacuum. You shall do that in order to minimize the risk of loss and maximize the rate of return, unless, under the circumstances, it's clearly not prudent to do so. So I've noted on this slide that caveat that allows you to, in certain circumstances, not diversify is actually a stronger diversification mandate than you see even in ERISA. What about divestment? Because divestment is almost by definition not diversifying. Yes.
Sorry, before we get to divestment,
Yeah.
is there an example of when a public pension needed to enact a diversification requirement that differed from ERISA?
I don't know of any specifically, and so it's a little bit hypothetical, but I think that I think it's important when you're talking about getting out of a particular asset class or even divesting, that you recognize that, well, ERISA says you are required to diversify unless it's prudent not to diversify. It has to be clearly not prudent to diversify in order to divest in a California context.
And would the opposite be true too? So if there was an asset class that a public pension is presently not in, but could yield higher returns, and it would be prudent to have more exposure to that asset class or to engage that asset class?
Well, you'd have to do the risk return analysis.
Yeah.
So it may anticipate a higher return, and then the question is, are you still minimizing risk sufficiently by being in that asset class?
Thank you.
Very good questions. I wish I had an answer for an example of my hypothetical, but I just noted it is important language, I think, to recognize in the California Constitution. So how do we deal with divestment mandates that the legislature puts into the statutes that apply to you? The answer is that, first of all, most of them have what I call a fiduciary savings clause. So they say you shall divest unless it's not prudent to do so, or unless it's provided that the prohibition satisfies the standards of the fiduciary duties of care and loyalty. So that's why you need to go through a fiduciary analysis anytime there is a divestment mandate. And assess whether or not that divestment meets your duties of care and loyalty. Next topic. Lest you think that all of this is on you as individual people who are coming to this board and don't necessarily have the expertise in all the different areas that I've laid out. Fortunately, the law does recognize that sometimes what is most prudent is for you to consult with experts in the field. And so that is what the Restatement of Trust says, that to the extent necessary or important for you to be informed in your decision making, that the duty of care also involves securing expert advice from those who know these areas, actuary, investment, legal, etc., on a reasonable basis. The implicit corollary to that is if you're not going to, if you have decided that you don't think that the best course of action is the one that is recommended by your consulting experts, that your proposed alternative course of action also should be supported by advice from experts.
the fact that you don't like what the three actuaries have said to you is the most appropriate course of action in terms of actuarial methodologies, presumably would not be sufficient from a fiduciary standpoint. You need to have other actuaries explaining why, in their judgment, their independent and informed judgment, a different course of action is advisable. Yes.
To what extent would a board member's own subject matter expertise apply in that kind of setting?
A board member's own subject matter expertise is the type of special expertise that should be shared with the board, but it is not in the role as advisor to the board. So I know that that's a bit of a nuance. You are not, as I said when I talked about, had that slide about special facilities and expertise being something you are actually required to share with the board. It's not that you're stepping in as, say, the general counsel for CalPERS. Nor are you stepping in as, if you happen to be an actuary, the actuary for CalPERS. But you can ask the probing questions, and you should ask the probing questions that draw out the issues that you see with the advice that's being provided.
Yeah, so at what point, if a board member has subject matter expertise of their own, can they apply their own expertise to their decision-making when confronted with, say, advice from an outside expert to the board that doesn't comport with their own expert opinion or views in a particular subject area, say an investment decision or impact of risks or liabilities associated with climate change or something like that a decision turns upon?
So each of you do need to exercise your independent judgment when voting on matters. Your judgment is informed by a variety of different sources, which obviously can include your own experience and expertise. I do think you need to articulate very precisely what the basis is within a particular field for perhaps disagreeing with a recommendation that's been provided by a retained expert. On the one hand, the board is not a rubber stamp for its experts and its retained experts. On the other hand, you are retaining them for their expertise. So I suspect that if your articulation of rationale were sufficient, that no court would, I don't think a court would find you in violation of your fiduciary obligations for exercising your judgment in that manner with your vote. But I would just caution people, particularly when you're getting into areas where people may be stating views that are more subjective and not truly based on informed expertise, that's maybe not a path to go down. Do you have any comments on that, Matt?
No, I think that states it pretty well. You've got the expertise of that pretty much states it. You've got the expert, you've retained him. If you've got another view, articulate it. If you disagree, it's on the record, and you go forward based on what your independent evaluation of the whole universe of information is. But it's tested against the expertise of the experts and your colleagues. Does that make sense?
And there would be no reason to have a multi-member diverse board as you do if you were simply always adopting recommendations that were provided to you. Really, that is your responsibility to ask those questions, to provide that input, to question one another as well in your decision making, and to reach the best collective decision that you can.
Ms. Brown.
Thank you, President Jones, and congratulations. Ashley, I'm wondering, to the extent that we do utilize experts, I'm going to assume they are fiduciaries to the board or to the fund, and that we have that in our agreements with them that they are?
I don't know about all of your agreements with all of your consultants, but for those who who have that trusted relationship under law, such as counsel to the board, counsel to the retirement system, that's imposed on the agreement as a matter of law. Now, one could try to write that out of an agreement under some principles of law. That is not something I would ever expect CalPERS to agree to. So it's that would be viewed as part and parcel of that agreement.
Yeah. And maybe I got to ask our own legal counsel. I would assume that all our experts are fiduciaries to our fund, and we've never released them from the liability?
Well, that's a really broad statement. We've got experts of all different manners, so I would want to look at what particular expert you're
I'm talking about the board
about.
experts, the ones like the Makitas.
Oh, yeah, absolutely.
Okay.
Yeah.
All right. And then,
And just sorry to answer that a little bit more. Those who are exercising discretionary who are exercising judgment to make recommendations to you that you act upon as fiduciaries, typically are the type of advisors who are fiduciaries, as opposed to those who are non-discretionary, say investment managers, where you have a specific mandate for them. They have no discretion. That would be less likely to be a fiduciary relationship.
And then I want to piggyback on David's comments about somebody with a board member with their own expertise, and they try to make an argument to the board members that maybe this is a bad investment or here's why this is a bad idea. And so there's a vote, and you're the board member on the losing end of that vote. If I was that board member, would I still have a liability if it turns out that decision was bad?
Typically, liability is not found simply because a decision doesn't work out. It's not bad. The question is the process and the considerations that were assessed when making that decision. And in my experience, courts will typically not try to other than the Shea example, will not try to substitute their own judgment for that of a diverse board where people express different views, vote different ways, and come out as the majority rules.
But is the liability that is shared by the board is shared equally, not individually, right?
It really depends how the case comes up, right? Because it's just like I've said in a litigation context, it depends if the person pays the filing fee, if an action's going to be filed. That doesn't mean it's meritorious. It depends who they name. They might decide only to name people who voted a particular way. So there are a lot of variables that impact how that type of situation would be resolved by a court.
Right. Thank you.
You're welcome.
Ms. Dunn, I have a question regarding investment decisions that resulted in a disagreement among board members. As you suggested, you may have a very strong opinion, you may have the expertise, and the final decision is not in accordance with your position, but yet still it ends up in a court. But it may be a situation where that's a long-term decision where you may not know the results until 10, 15 years later. So do the court just say come back later when the results are known, or how do they handle that?
I think the answer goes in part to my earlier answer, which is what the courts will look to typically is the process engaged in at the outset. Now, I say that recognizing that a valid made defense potentially could be no harm, no foul if there's no loss, et cetera, et cetera. I mean, that may be one defense that's being asserted. Whether a court would allow it to proceed in that context or not, I don't know. My view is it's very difficult once you're in litigation, but you do need to continue to exercise your fiduciary obligations as you go along. It may have been the challenge may make people a little bit more concerned about it, but they still think that the majority still believes it was the right decision and you stay the course. Circumstances may change in the course of the litigation that have nothing to do with the litigation, which mean you need to change your course of action. So those are all factors that you would need to consider as a board. it's very complicated to assess sort of hypothetically what the right course of action would be in that circumstances. But what I'd say is keep your ears open, keep your eyes open, keep asking questions. There may be opportunities where you need to speak with your counsel in a closed session context to assess the various risks that we're talking about. But that's going kind of down a different road.
Yeah, if I might state that somewhat different way, if the court is unable to evaluate today whether it's a bad decision or not, then you're pretty much in the clear, because if it requires an additional time period, then it almost necessarily cannot be a bad decision today. Now, there are situations where I suppose it could be. You could objectively determine, yeah, this is going down the wrong avenue, but it's really only in retrospect, when it's clear that the decision was the wrong one, that I think you even get into this inquiry. And then as Ashley was saying, you don't look at whether the decision turned out to be wrong, but what was the process. So you go back to the time of the decision and determine what was the process and was it a fair process, and if you are, you're good. Now, you layer on top of that what Ashley said earlier about the duty to monitor. So every few years, or whatever the appropriate time period is, you have to go back and look at it and evaluate, are we still on the right track?
I just put an additional caveat on that, which is there will be some areas like the situation we saw in the O'Neill case, which involved an actuarial methodology change that was adjudicated, even though the consequences of it were longer term. So in an investment context, I think there might be one answer, and in a different, like an actuarial context, there might be a slightly different answer. And on the investment side, it really depends what the nature of the challenge is. Is the challenge it was imprudent because you're going to lose money, or because it was too costly, or because there are some things that can be assessed earlier than other things. So obviously it's very nuanced in terms of where you can fall into, where you can get in trouble or have somebody challenge you. There are all sorts of defenses that you might assert if something like this, if you were alleged to have violated your fiduciary duties. This isn't a litigation course. This is more how to try to make judgments in the first instance in compliance with your fiduciary obligations, and hopefully you'll stay out of litigation if possible, but that's not always possible. Okay. Oh, I don't think I've touched delegation yet. Okay. So the law used to be that the trustees had to personally perform obligations of a trustee. Thankfully, that's not the law that applies to you. Sometimes the most prudent course of action is to delegate certain responsibilities to others. And CalPERS, obviously, given your size, number of members, the assets, the complexities, that there's a lot that a prudent person would and does delegate. The delegation itself has to be prudent, though, and that takes us back to the Howard versus Shays case, where even the fact that the fiduciary in that case had secured independent advice didn't necessarily result in them being deemed to have acted prudently, again, in the context of what was viewed to be a self-interested decision. Prudence involves, in terms of delegation, involves these four fundamental questions. First, is this something that I should be delegating in the first place or not? If it is, then how am I going to go about that delegation? To whom the task is delegated is really important. And then once it's all of those actions have been taken, how do I supervise? And here's just another citation relating to prudent delegation. Just a couple of additional topics before we move on to duty of loyalty, and I think these tie most into the duty of care that applies to all of you. There's some really important confidential information that you as board members receive. You receive health information relating to your members. You receive investment information that's proprietary. You receive confidential attorney-client communications. As part of your duty of care, your duty to your co-fiduciaries on the board, and your duty to CalPERS and its membership, it is imperative that you not disclose confidential information without the board having made a determination to waive a privilege, if that's who holds the privilege. I've added a slide on governance here. We had a discussion a little while back about your governance policy, and so I thought it was worthwhile to mention this, that you have a very robust governance policy that articulates the legal authorities under which you operate, that sets forth governance principles to which you've all committed, identifies the responsibilities that you each have as individual board members, delegates certain specific responsibilities to the board president and vice president, and to chairs and vice chairs of committees, and also delegates important responsibilities to your executives and identifies their reporting relationships. So, compliance with your fiduciary obligations in terms of your duty of care also means that in addition to following the plan document that we've already talked about and the other applicable laws, that you also endeavor to follow the very policies and practices that your board has adopted over time. Final slide on duty of care is the duty to maintain the tax qualified status of CalPERS. The retirement system is not subject to ERISA, but it is subject to Section 401A of the Federal Tax Code, and that has very specific requirements about what you can and cannot do in order to maintain your tax qualified status. And why is that important? That's important because, and I'm not a tax lawyer, so if I get this wrong, sorry, but my understanding is that the benefits of maintaining tax qualified status are that the earnings on your investments are not taxed, and that the retirement benefits that your members earn are not taxed until they're received. So you could be eligible to receive it at a particular age, but you're not taxed on it until you start to receive it. So those are really important to your membership and to, in terms of that immediate consequence on their taxation, and also in terms of the fund, in terms of your investment portfolio. So you will hear this topic come up from time to time through your general counsel or your tax counsel about a particular action potentially not complying with federal tax qualification rules. That's what that comment is about. There's a very helpful case on this that came down several years ago, where the San Diego City Employees Retirement System submitted a voluntary compliance plan to the IRS and entered into an agreement with the IRS that said, okay, we understand that these certain parts of our plan actually violated IRS rules, and reached an agreement as to how those would be resolved. One of these was a very well-known situation because it was the subject of several lawsuits, including the Lexington case before the California Supreme Court, and that was the inclusion of payments for union presidents' time on the board in their pensions. And that is a payment by a private entity to secure a public employment benefit that was not permitted. You can only have governmental salary be used for the purpose of calculating public retirement benefits. And so the IRS said, you can't do that. You have to unwind it. And SD-CERS was sued over that because obviously people didn't like to have that taken out of their retirement allowance. And so the court included this really very helpful observation that part of the plan is to comply with IRS obligations, and so there was not a breach of contract by virtue of the SD-CERS compliance with its VCP. Fiduciary duty of care, summary slide. What does it require? It requires that you ask questions, understand the rationale of actions before you take them, you analyze advice and recommendations that are given to you, you're not a rubber stamp, that your actions are informed by the expertise that's implicated by the decision, and that you follow the plan document and policies and rules applicable to the organization. Moving to fiduciary duty of loyalty. The first and very important aspect of this is the exclusive benefit rule. Trust funds are to be used for the exclusive benefit of members and beneficiaries of the plan. They're not to be used for other purposes. There's a note about defraying reasonable expenses of administering the system. Obviously, you use assets of the trust in order to run the system. That is, I think, understood to be part of the defraying reasonable expenses of the retirement system. It's all for the benefit of paying your members their retirement benefits. The California Constitution also has in addition to the actuarial part of it, it has this other important loyalty aspect to it related to retirement services specifically, and that is that you're to administer the plan in a way that assures the prompt delivery of benefits to your members and beneficiaries. So there's a timeliness aspect to it as well as an accuracy element that is critical. The next slide quotes a provision of the Constitution that gets a lot of discussion because it has, it articulates a couple of seemingly competing principles. But the last clause that I've italicized is the articulation of the primary duty rule. So what it says is that you are to exercise discharge your duties with respect to the system solely in the interest of members and beneficiaries. Then it says minimizing employer contributions and defraying reasonable expenses. With the final clause being the primary duty rule, the board's duty to the members and beneficiaries takes precedence over any other duties. There are a couple of cases that talk about this sort of articulation of duties, and what I would say is that minimizing employer contributions is not a fiduciary duty because you don't have a fiduciary relationship with your employers. It's a constitutional secondary obligation. And what does that mean? That's the subject of a lot of debate. One thing it means is that you can't be so risk adverse or conservative in your investments that you are not complying with your ability and authority to follow modern portfolio theory and invest broadly in order to actually make money on system assets, I think. Because that would be artificially inflating the employer's contributions to the plan because you're not making your investment returns. That's one way. Other ways, perhaps there would be a desire to over-fund the plan substantially so that you make sure that you would have enough money regardless of what happens in the future. You want to be 150% funded rather than 100% funded. That doesn't sound to me as though it necessarily complies with the minimized employer contribution obligations. Your target should be 100% funded, and that's a long-term goal, but that is where you should be heading. So that's how I've understood it to operate, and I think it's supported by the case law in California to the extent there has been some. Collateral interests of board members. Okay, so citing the O'Neill case again, and this had to do with the employers, and the question was whether the retirement board, in making these actuarial changes was putting the interest of the employers over those of the members and beneficiaries. And that is why it is that question that resulted in the case being remanded for a third time for a trial. And there was a long trial during the summer of 2019, on that topic. And I've included the quote here because I think it's an important one. An abuse of discretion occurs when a trustee acts from an improper, even though not dishonest motive, such as when the act is undertaken in good faith, but for a purpose other than to further the purposes of the trust, or more specifically, the purposes for which the power was granted. So the power that this board has is to take actions that are reasonably necessary to ensure that you pay the benefits that have been promised to your members and beneficiaries in a variety of different ways that you do that. So that was the question that was posed and remanded to the trial court. The Board of Retirement prevailed after trial, and I'll get to that in a few slides, but I think it is important to note that it did take a trial to get there. Collateral interests. What if you have really strong views on a particular topic? You have a very strong interest in something that that would normally inform you in the management of your own investment portfolio, for example. Just as one example. Those are not to dictate or to influence how you act as a fiduciary on the CalPERS board. The membership of your organization, of your plan, the members and beneficiaries of the plan have, in many cases, quite different interests from one another. You have your retired members who are no longer paying contributions into the system. You have your active members who are. You have members who will be PEPR members and members who are classic members. You have safety members and you have miscellaneous members. You have people who joined yesterday as a 20-year-old who may have a really different employment trajectory than somebody who's a 30-year employee. So there's a recognition in trust law that as you make various decisions that impact beneficiaries with such different interests, that it's not always clear what the right answer is, because something that's good for one may not necessarily be good for the other. And so the mantra that we've come up with over the years is that what you're aiming to do is to act in a way that serves the overall best interest of your members and beneficiaries. Fortunately, this is not new to trust law, that the idea that there are different sorts of beneficiaries of trusts. There are income beneficiaries who take from the trust during the life of the trust, and there are remainder beneficiaries who get everything that's left over. That's very common in private trust law, and trust law has evolved to recognize that. So you do have quite a bit of discretion when balancing interests. On slide 52, I've talked about or articulated several different factors that you might consider when this type of question comes up. First of all, of course, you look to your plan. You determine whether there's a way to answer the question under your plan document. Potentially, there may be room for equitable considerations at times when you look at the number of people involved, the degree of hardship. There may be a consideration of equities potentially between members and beneficiaries. Certainly look to the questions of law, such as vested rights and whether any vested rights are implicated. There is a vested right to the actuarial competency of the retirement system to pay the promised benefits. So that's something that you can look at too. I see confused looks, or no, are we good? Okay, all right. So next, the fiduciary duty of loyalty recognizes or reflects this important recognition that you are not acting as an agent for anyone else once you get on the board. You all come to the board from different places, whether you're elected by active members or retirees or appointed by the governor or are an ex officio member. Once you are here on the board, you are all fiduciaries acting with the same obligations to serve members and beneficiaries of the plan. And I've set forth a couple of California legal authorities for that. There's some interesting language around Prop 162 that I mentioned earlier in connection with actuarial services. There's some pretty strong language in there too about the importance of that language as a way to try and prevent meddling, political meddling or interference by the ones who elected or appointed you to the Board of Administration once you're on the board. So be mindful of that. And LRB versus Amex is a famous U.S. Supreme Court case that talks about this in the ERISA context and specifically says what I just articulated, which is once you're on the board, you're not an agent for the one who put you here. What about employer contributions? I've already talked about this a little bit. There's a case called Bant versus Board of Retirement, where that minimize employer contributions provision was specifically discussed. The court didn't specifically conclude one way or the other exactly what it meant, but it did, in that case, uphold a retirement board's decision to adopt an interim valuation, which recognized an inflow of an additional $100 million that the county had put in, even though the consequence of that, the only consequence of that really was to reduce the employer's ongoing employer contributions. And the court said that taking that additional money and being a good administrator of the plan and somebody that the county could rely on to recognize it in a timely way was not a violation of fiduciary obligations of the board. What I'd say about this particular topic is it's not going to be a breach of fiduciary duty typically as long as the actions that you're taking are not compromising the assets of the benefit of the system to pay benefits. There is no conflict of interest in what you're doing, and you've been able to articulate why it's in the overall best interest of your members and beneficiaries to take the actions that you're considering. The Bant case had some language about the interest that members have in keeping their jobs, with sort of a throwaway line about, well, it's certainly not in the best interest of members to get terminated. True, but so the question is, as trustees of a retirement plan, is that what you should be looking to? The O'Neill endorsed Bant to some degree and said a retirement board could consider its active members' interest in retaining their jobs when making funding decisions, because that also benefits retirees in the sense that when you have an open big plan that's enrolling new people, that's keeping actives, getting all those contributions in is good for the system. It's good for the members and beneficiaries. But again, that's a case where a trial had to ultimately assess whether it was in the best interest of members and beneficiaries to have taken those actions. And the court cautioned here, there's an issue of fact, so something that needs to be decided by a, in this case, a court, not a jury, but a court, as to whether the board's balancing of a single year of improved jobs prospects against a perpetual funding shortfall that could leave the pension system unable to pay benefits violated the retirement board's duty of loyalty. So that was the question. If you're looking at a 1-year employment issue versus long-term stability of the plan or ability of the plan to bring in what it needs to pay promised benefits, that balance may not support the short-term decision. In this case, though, the court said that there was no breach of the duty of loyalty. This is after trial. It's been appealed. And the evidence that the court focused on, as I said, was the process that the board engaged in, including a number of statements that were made in public session, both by board members and to the board, by those who were supporting the action, including retirees, regarding the rationale for the decision making. The court looked specifically to the legal and actuarial advice that the board received in that context and determined that the board had acted conservatively to ensure that members would receive vested benefits in what the court characterized as a 5-alarm fire. And they said the court concluded there was no clear evidence that the board took action solely or primarily to benefit the county or to place the interests of the county ahead of the plan members. So once again, really looking at what the rationale is for the decision making to assess whether it complied with the fiduciary duty of loyalty. The plaintiffs have appealed that decision, and it'll likely be decided probably end of this year or next year. So what do we do with all of this? Recognize that the fact that you have plenary authority over administration of the plan and investments of the funds of the plan, and that's considered an exclusive authority, is not absolute discretion. It's discretion that has to be in compliance with your fiduciary obligations. How do you do that? How do you avoid an abuse of discretion? Process is really important. We've said, both your General Chief Counsel and I have said, process. Make sure that the record reflects your deliberations, that your agenda materials, your backup, all is sound, that the minutes reflect, or at least here you have your transcripts of your meetings. You have a lot to show what has been acted upon and why. Education, as you're doing right now in terms of fiduciary education, also investments, actuarial. That's what this whole retreat is about, or this session is about. And as to specific decision making, make sure that you're engaging in that same sort of deliberate, informed inquiry. Always ask the question, is this in the overall best interest of our members and beneficiaries, and why? Continue to maintain active, independent oversight in your key areas, your investment, your actuarial, legal. And my final slide, which tries to sum up all of this into one statement, which is that you're to use your informed judgment to act in the overall best interest of the system members and beneficiaries. It's not to the system, it's to the members and beneficiaries in a manner that's consistent with applicable law in the areas over which you have authority, which is your administration of the plan and investments, and that nothing that you do is arbitrary. You may not be arbitrary. Please do not use that word to articulate anything that you are doing, because it may not be arbitrary. It must be prudent. It may not be capricious. It may not be out of ill will towards anyone. And it needs to be rationally related to the information that's presented to the board. And that is the end of my presentation. And I think I have 5 minutes if you'd like to use them.
Thank you. We have some questions. Ms. Middleton.
Okay. Hi, Ashley.
Hi, Lisa.
Can we go back to the O'Neill case? The court ruled that the trustees acted conservatively to ensure that the members would receive vested benefits.
Which slide number are you on?
I'm on number 58.
58.
I think.
Yes.
Okay. What's the theory of the plaintiffs regarding what the trustees' obligation was?
The theory of the plaintiffs was that the board was taking actions that were in the interest of the county, and that were not in the best interest of the retirees in that case, who received supplemental non-vested benefits out of a particular fund. So I'm really simplifying here, but there was a fund that had assets, so-called excess earnings, put into it that could be used for non-vested benefits.
And that was a very specific targeted group of individuals?
I think it was just retirees. I think it was it was any retirees.
So the broad group of
yes,
retirees.
once people became retirees.
All right, thank you.
And it may have been supplemental COLAs or something like that. So that's the theory, that they were putting the interest of the county over that of those who would otherwise get those benefits through supplemental COLAs.
Ms. Shee.
Thank you, Ashley, again. On the duty to diversify, just wanted to explore something, and it really speaks to, I think, some of the governance principles that we try to utilize from time to time, and that is, under this duty, is there an expectation that the board ensures that CalPERS owns the market, or can we make a case that certain companies can be excluded because they do violate some of our principles? Like, I'm thinking about the dual class share discussions that we've had in the past.
I don't think that you would be held to an obligation to hold the entire market, because you are making judgment calls about where it's prudent to put system assets. So the question in terms of complying with principles that you've articulated elsewhere is, what is the basis for those principles having been adopted? And if the basis is that the investments are more sound, or for the reasons that will be articulated, then there probably is sufficient correlation between the economically based rationale and for those principles and the investment decisions that follow from them.
Okay.
I mean, I
So
could
that-
answer a lot of different ways on that, but I talk about this in terms of, you talked about dual shares. So that's a governance issue.
Right.
And so the question is that governance principle something that you believe is impacting bottom line? And that's something that you consult with your investment advisors about, as well as others, to make your assessment about how it plays out in the context of your actual portfolio.
Okay, good. And then my other question, after the actuarial presentation this morning, on your slides that talk about employer contributions, given that we've got employers in the system that are of varying financial conditions, I guess, how do we interpret the case law or apply the case law regarding lowering employer contributions?
The key question is, are you setting employer contribution rates and terms in a way that is going to assure that they are paying what they're required to pay in order for you to then pay their retired employees their money when it's owed? Because the fact that they're having troubles now, if that means they're going to have troubles 5 years from now and 10 years from now, maybe a different situation from, say, the 5-alarm fire that was the context of the O'Neill decision. So ultimately, you have to be paid in order to be able to pay the promised benefits. And whether that means that you adopt different approaches based on the circumstances of different cities or counties, I don't know. I think that's beyond where I should go in this discussion. But I'd say the key question is, are you going to be able to pay now and reasonably into the future, both short and long term, based on the methodology that's been proposed by, say, your actuary?
Okay, I see no further questions at this time. We want to thank you again, Ms. Dunning.
Thank you
and
for having
Mr.
me.
Jacobs for the presentation. How about a applause? Okay, Mr. Moles, you're next up.
We just need a minute to.
Yeah. No, we're going to go right on.
I'm going to try and make up some time. We've got a time certain at 4 o'clock.
Yeah,
Yeah.
okay,
Yes.
yeah. We'll
You
give you
have
2
about 10
minutes.
minutes, Don.
Okay. Well, I think I